I'm here with Chairman Houston of the Commission, and this morning we're here for cause number 46183 for an attorney's conference. This case is regarding the verified petition of NIPSCO Generation LLC for certain determinations by the Commission with respect to its jurisdiction over petitioner's activities as a non-retail generator of electric power. So the purpose of our attorney's conference today is to discuss the procedural schedule. We're not on the record. We're simply discussing non-substantive matters. So if you can bear that in mind, we'd like to work out a procedural schedule going forward in this case today, okay? So for the people watching online, I would appreciate it if counsel for each party would introduce themselves just so that people online can know who's here today. So I'd like to start with petitioner, please.
Thank you, Your Honor. This is Brian Likens, representing both the petitioner, NIPSCO Generation LLC, as well as the intervener, NIPSCO, the utility.
This is Lauren Aguilar from the law firm of Barnes and Thornburg LLP, same as Mr. Likens, representing Genco and NIPSCO.
This is Nick Kyle, Barnes and Thornburg LLP, also on behalf of Genco and NIPSCO.
I'm Robert Hicks. I'm representing the United Steelworkers Union.
Ron Gilbert from Polsinelli LLP. I'm here on behalf of intervener DX Hammond. I believe my colleague Christine Soares is online as well.
Good morning, Your Honors. Jennifer Washburn on behalf of Citizens Action Coalition of Indiana. Thank you.
Good morning. Thank you, Your Honor. On behalf of interveners, Invenergy Renewables, and Tuckaneck, Inc., Christina Kern-Wheeler of the law firm Barnes and Thornburg. I work for Barnes now. Bose, McKinney, and Evans, Indianapolis.
Good morning, Chairman, Judge. Clayton Miller, representing intervener Clean Grid Alliance, and I also have Elizabeth Wheeler from Clean Grid, who is online.
Good morning, Shaw Friedman on behalf of the LaPorte County Board of Commissioners.
Good morning, Emily Vlasic from the law firm Lewis Kappas on behalf of the Industrial Group.
Joseph Paula from Lewis Kappas, also with the Industrial Group.
Adam Cashin of the Indiana Office of Utility Consumer Counselor.
Jason Haas, also of the Utility Consumer Counselor.
Okay. I see there are also some attorneys online. Ms. Soares, I understand that you're here for EX Hammond with Mr. Gilbert. Would anyone else like to introduce themselves? We could start with, I see Ms. Wheeler is here for Clean Grid Alliance, and there's also Ms. Drake, if you'd like to introduce yourself.
Hi, good morning. This is Elizabeth Wheeler on behalf of Clean Grid Alliance.
Thank you.
Carol Sparks Drake, also here with the Office of Utility Consumer Counselor.
Thank you. Mr. Doshi, would you be able to introduce yourself, please?
Thank you, Samir Doshi for Citizens Action Coalition. I'll just be listening.
Okay, thank you very much, everyone. So I understand that, Mr. Likens, you've proposed a procedural schedule that was contained in your filing yesterday. Will you stand by that? No updates to that at this time?
That is correct, Your Honor.
Okay, thank you. Mr. Hicks, what is your position on the procedural schedule? Are you okay with that, or would you suggest some different days?
I'm going to defer to the other counsel here. Frankly, like all the other parties, I think some of this is just kind of coming into our lap. So I'll let other parties speak to that. We're okay with whatever the commission decides, but you know, we would think that more time might be helpful in this particular situation.
Thank you. I'll bear that in mind, and I'll just keep going down the row and asking your thoughts on that proposed procedural schedule. Mr. Gilbert?
I don't have anything at this time. Christine, if you want to chime in if you have anything, but like my colleague to my right, I'm going to defer to the council here, and then we'll chime in if we have any more with regard to our position.
Thank you, Your Honor. Jennifer Washburn on behalf of CAC. I think it's important to note, as the settling parties flagged in their joint notice, we have now reviewed the term sheet, and the commission has not yet had that opportunity to see the terms. And to be frank, we have a lot more questions and many more concerns, which is likely why you'll see some unified positions here on behalf of the non-settling parties. You know, in terms of what happened, how it happened, but also what's appropriate for proposing a schedule and next steps going forward. You know, frankly, we've been here before with NiSource and the industrial group in particular in 45772, 45159, and I know there's one other case, but I couldn't find it in the haste of the past 48 hours. We have issues such as responses that would need to be revised, discovery responses. As you know, we've had a lot of issues with that. Right now, the timeline of the discovery, which the settling parties did not offer to revise, because they, you know, while they sent the draft notice, they gave us a 10 a.m. deadline to provide feedback on the draft notice, but they filed it at 8:10 a.m. So none of the other parties, to my understanding, were able to weigh in on this. But the discovery schedule right now says 10 calendar days. And given the difficulty that we've had in getting answers, and as you know from the prior attorneys conference that was contested, the schedule has been really difficult to keep up with. And as I said, the term sheet raises a lot more issues and conflicts through the summer and other case schedules. The original pre-hearing conference order required, as you know, 10 business days before the hearing to file the settlement and evidence. But it also had 81 days between the petitioner's filing and the OUCC and interveners' testimony date, and then 22 days between the rebuttal and hearing, and then the hearing date got altered, so it was actually 25 days. Again, I just want to reiterate, you haven't seen the term sheet, so it's hard for you to understand where we're at right now, but we have a lot of questions and concerns. And the settling parties note in their notice that their settlement resolves all of the issues, resolves all the disputes, claims, and issues in this cause, which presumably are our issues, claims, and disputes as well. The other part that I just note is, you know, this has been difficult in terms of the behavior and the litigious nature of this case. And, you know, one of the major issues that has been in dispute has been whether or not the commission will decline jurisdiction before we understand the details and the baseline terms in the power purchase agreements and the special contracts. And to be frank, this process and the way that the settling parties have treated this process just really reiterates our concerns. I apologize for, it's hard to separate the substance from the procedure here, because that's all to say that we need a lot of time here. And I think following the same cadence and the, you know, as I just laid out with the pre-hearing conference order is appropriate. And I will defer to the rest of the non-settling parties now.
For sake of clarity, Jennifer, you're asking for 80 days to review the term sheet and offer testimony?
Well, we have not yet seen a final settlement. We have not seen revised discovery responses. We have not seen your case in chief. The pre-hearing conference order required that all of those items be provided 10 business days before the settlement, or before the hearing, rather. I know that it's been petitioners' thoughts that, or desire to get an order quickly. And I think if that was the desire, then that schedule should have been followed, and we would have all been bound to that. But now we all have other obligations, and we have to reorganized. And as we mentioned, the discovery issues, the way that I have to be careful to not reveal what the terms are, but discovery needs to be revised. So it's hard for us to make a good decision about the amount of time. And so yes, my position at this point is that we should follow the cadence of what was the difference in time between the different deadlines as was laid out in the original pre-hearing conference order. Thank you.
Okay, thank you. Ms. Wheeler?
Thank you, Your Honor. I would just say, trying to stick to the issues of procedure, that if the commission is going to put settlement deadlines in a procedural order, that those deadlines need to be followed and respected. And when they're not, there should not be an expectation, particularly when there is a settlement of 2 out of, I lost count, 8, 10 parties, that the settlement then be very quick, which I think is what is happening here. It's a very quick proposal. I do oppose it on behalf of both my clients. It is not going to allow us to do much, if any, discovery on the settlement. As Ms. Washburn stated, we were not part of getting this term sheet together. It does, frankly, for me also raise more questions than it answers, and it purports to settle it on behalf of all parties and all concerns. And as you well know, those concerns were quite varied. So I would ask the commission to set a more reasonable and longer schedule than what the settling parties have proposed. Thank you.
Thank you. Mr. Miller?
Thank you, Your Honor. On behalf of Clean Grid Alliance, we share many of the concerns that have already been raised. I note that in the response to the objection that another party filed to continuing today's hearing, the petitioners responded that they would not be able to offer their evidence as originally filed, and that they have modified the scope of the requested relief. It's essentially a new petition. We don't think the schedule that they have proposed is at all reasonable. I think if you're asking for what kind of number we would be seeking, I understand the CAC's proposal and certainly don't oppose that. We were thinking something more like 60 days from the date that they actually present their case in chief, their modified case in chief, in support of the settlement.
Okay. Mr. Friedman?
Yes, thank you, Your Honor. Certainly in concurrence with what my colleagues have shared this morning, and I want to talk about a procedural issue if I could, because that's what I understand the purpose of this morning is about. I've been instructed by my clients to express some concerns procedurally at this time. When it came to the motion to dismiss, my clients were well aware that such motions are within the sound discretion of a court or administrative body. We took our best shot, and it was certainly, and we understand it was deemed denied May 2nd. But when it came to a motion to vacate an evidentiary hearing that was filed less than 48 hours before trial, based on my nearly 41 years of trial work in federal and state courts, there's no judge that I've been in front of that would grant such a motion in multi-party litigation where only one party had settled. Now, I further gave my client assurances mid-afternoon yesterday when we determined that this commission's own rules for continuances at 170 IAC 1-1.1-20 requires that any motion for continuance filed within 7 days of hearing must be verified, which did not occur here. And the moving party must, and I repeat, must, state the position of all the other parties to the case on the issue of continuance. Again, that did not happen. In fact, that rule wasn't even referenced in this body's ruling late yesterday, which prompted one of my clients to ask me at the end of the day, Shaw, are we going to get a fair shake in front of this commission? And I must tell you, that's pretty unsettling as a practitioner. I've been a member of the utility bar for 25 years, practiced in front of this commission, and I want to always be able to assure my clients, the elected officials of LaPorte County, that we can expect fair and equal treatment in front of this commission. We simply ask that we all be required to adhere to and be bound by the same rules. Thank you.
Did you have anything about the procedural schedule that you'd like me to consider today as well, Mr. Friedman?
Longer the better. It's a new case, and it's anywhere between the 60 to 80 days that have been tendered would be acceptable to us.
Okay. Thank you. And Ms. Vlasic, Mr. Rampala?
Thank you, Your Honor. Certainly, as we are joint signatories to the settlement agreement or to the standing term sheet as now and the request, we would echo NIPSCO's proposal and certainly would like to see an expeditious resolution of this case. I would say further that with respect to the requests that are being made for 81 days, 60 days, 45 days, this commission routinely handles settlement agreements and receives them, and parties are given appropriate amount of time that is not treated as though it is an entirely new case that has to be dealt with as though the procedural schedule starts again. So I don't believe that when the commission is taking into consideration the appropriate amount of time, that is an appropriate standard to be applied here. With respect to any of the other issues with regards to the level of notice, the level of prior disclosure with regards to communications, I simply, would like to point out that NIPSCO and Genco were very clear with us and all other parties that they were available for discussions. We communicated with them. There is no rule of which I am aware that requires all parties to participate in settlement discussions. And I believe that as time goes on, the matters and the facts will be laid before the commission with respect to all of those concerns. And the commission will ultimately have to make a decision here based on the record with respect to the request and the evidence presented in support of the request on behalf of Genco. And now at this point, that which would support the settlement agreement. So I simply think that we need to make sure that we focus on the points here with respect to the timing that needs to be addressed. Certainly due process is in order, and an opportunity for discovery and for other matters to be addressed. But I do believe that that can be accomplished in an expeditious way, as the commission has consistently done in prior proceedings. Thank you.
Okay, and next we have the OUCC.
Thank you, Your Honor. I'll leave it up to my colleagues to work on the specific number of days. I will just point out that in the response yesterday, petitioner did indicate that this is a new case and there are new terms that are before us. And as my co-counsels or other counsels have indicated, there are substantial concerns about some of the terms that have been presented to us. So I would just like to make sure that you take that into consideration when you determine your procedural schedule.
One quick clarification, if I may, Your Honor. Speaking at least for my client, the 60 days that I proposed was going to be the date following their filing of their case in chief for the responsive evidence from the other parties.
Your Honor, if I may respond briefly.
Yes.
I would state, first of all, we do, in essence, echo what Mr. Rampala said. As to allegations, claims that this is an entirely new case, both based on what we filed as well as the term sheet that has been provided to other parties, I don't know how that can be stated with any certainty or frankly, clarity, because it's absolutely not correct. Everything that is in the term sheet that has been shared, I would be happy to talk very big picture concepts, if it would give you any comfort or let you have some understanding without revealing anything that is confidential, is very consistent with our petition and is consistent with the issues that were raised in testimony by the other parties, as well as the rebuttal and cross-answering. There's nothing really that goes beyond what the petition was originally asked. So any allegation this is somehow a new case or a new case in chief is frankly just completely wrong. As in a normal proceeding, you go through the procedures, you then get into settlement discussions. We did host an all-party settlement discussion on the 28th and shared a term sheet in advance. Only one party engaged and turned a complete term sheet to us, which was the industrial group. We offered to have settlement conversations with any party who would like, and did have conversations with multiple parties following the 28th. I would also point out that while folks may want to ignore the fact, NIPSCO is also an intervener in this case. So this is a three-party agreement with a single party, as well, the petitioner and two additional interveners. And then from a procedural perspective, ordinarily in rate cases and those sorts of things, which are much more involved than this sort of case, traditionally a period of around 3 weeks from the time of the filing of a settlement agreement and testimony is the ordinary time for responses. We've proposed 3 weeks in essence from yesterday. We would not oppose if folks wanted an additional week, and let's go 3 weeks from when we file our testimony on the 14th. But the idea, again, that this is some new case in chief or an entirely new procedural schedule is required, to me is extraordinary, and I've never seen that sort of request in a settlement, whether it be a rate case or a large generation filing or those sorts of things.
Your Honor, may I please?
Yes.
Thank you, Your Honor. This is an issue, settlement procedure, that CAC has raised time and time again, and we continue our adamant request that mediation and commission involvement be involved in some of these cases, because to be frank, it's one thing to say we invited you, and it's another to say that we provided feedback, and the feedback to our issues was thanks but no thanks. So when they find a willing party to get accomplished what the willing party wants accomplished, it's hard for the rest of us. And going back to the scope issue, may I, Mr. Miller? Yeah, that one. In the response to objection to request to vacate the evidentiary hearing, on the second page, on the second full paragraph, it says, otherwise, when Mr. Parisi is called to the stand and asked whether the answers to the question in his pre-filed testimony would be the same, his answer would necessarily be no. This is because the term sheet entered among Genco and two interveners, NIPSCO and the NIPSCO Industrial Group, has modified the scope of the requested relief in this cause. This is a new case. We have seen the term sheet, and the commission would probably benefit from seeing what has been agreed upon before deciding the procedural schedule. Thank you.
Okay, I'm going to take a moment. All right, so the chairman and I would like to take a break and take a moment to talk to staff about everything that's been said this morning. Is there anyone else who would like to state something before we go on that break? Mr. Gilbert?
Yes, Your Honor. I just wanted to say while we have everybody listening to my colleagues here today, we would prefer if some discovery would be worked into the schedule sometime after settlement testimony and before the other party's testimony is due. Of course, with sufficient time for the parties to serve and for NIPSCO and the settling parties to respond. That would, I think that would be the position of DX Hammond at this time. I don't see any discovery worked into the current schedule, but I would ask that the commission consider that with regard to the procedural schedule.
Mr. Miller.
Also, Your Honor, just a quick clarification. I think Mr. Likens misspoke. I'm sure it was unintentional, but there was at least one other party which also responded to the term sheet and provided red line of the term sheet after the settlement agreement, or I'm sorry, after the settlement meeting to engage in active settlement negotiations. Those did not result in a settlement, but my client did engage in further negotiations.
Fair clarification, Mr. Miller. And I would note my intention was to refer to a term sheet turned to all parties. Understand you did send that to us directly, so appreciate the clarification.
May I make one clarification on the discovery, please?
Yes.
And I apologize if I already mentioned this, but right now the pre-hearing conference order, which the joint notice says maintain all the terms as are in the original pre-hearing conference order. It calls for 10 calendar days. Normally we see, after rebuttal, I guess depending on what the length of time is between rebuttal and hearing, we would ask that be revised down to 5 business days. And then also some type of directive that, when the case in chief is filed, that the prior discovery requests be revised at the date that the new case in chief is put forward, because we've all put in a lot of work in that front, and now these answers are no longer valid. Thank you.
We would not have an objection to a 5 calendar day turnaround for discovery. I think that's reasonable for Ms. Washburn, especially if we're talking somewhere around 21 days or a little bit longer, to ensure they could have a turn or two of discovery, or excuse me, business days. 5 business days would not be problematic. I would note there's not an intention to revise discovery request. I've never been involved in a case when a settlement occurred where a party was directed to revise prior discovery requests, but to the extent additional discovery requests would like to be asked, we obviously could answer them with respect to the term sheet or the ultimate settlement agreement.
Your Honor, I just also, and I'm sure that, and he can speak for himself, but I'm sure that Mr. Likens would agree that my client also met one-on-one with NIPSCO and Genco to have the conversation about our settlement concerns as well. So it also is not accurate to represent that none of us responded, although I will note that it's difficult to respond when a term sheet doesn't include your issues and you've said what your issues are and they just get ignored or set aside. But that said, my personal style is, and I did let all the counsel at this table know that I spoke to them, was having separate conversations out of transparency and consideration for what we were doing, and that did not get returned by those that settled this case.
And again, in case I was unclear, I noted that we offered to talk to parties, and we did speak to every party that asked us to. So while we may not have turned to term sheets, as I noted, we did have discussions with multiple parties. So again, was not indicating there was only one party that we spoke to. So apologies if that was unclear.
Okay, thank you, everyone. We're going to take 15 to 20 minutes. It's almost 10 o'clock, so let's plan on being back around 10:15 or so. Okay, thank you for your patience, everyone. It's 10:15, so we're continuing our attorneys' conference. We would request, Mr. Likens, that the settling parties submit the term sheet to the commission. If you can send that to us today.
We will do that very promptly following the hearing.
Okay,
Attorney's conference.
great. And then we would like for you to file the settlement testimony and agreement on May 14th as suggested in your filing yesterday.
No problem with that either, Your Honor.
Okay. And regarding the rest of the procedural schedule, we've listened very closely to everything that you have said today. We will take the time to consider that, and a docket entry procedural schedule will be forthcoming. All right. Thank you so much, everyone. That concludes our attorneys' conference.